So yeah, that's the difference that you can be wary of. Now, what are the kinds of trademarks? We've discussed what trademarks mean. They are the brand names. Now, there are very many number of trademarks that you can have. You can have a word trademark. Word trademark is essentially just a word mark. So, when you're seeking to register McDonald's, if you just write McDonald's, then that's the word mark. There are service marks also. So, for example, if you are trying to establish yourself as a service provider in a particular domain, then वहां पर आप अपना एक स्पेसिफिक सर्विस मार्क का सिंबल यूज कर सकते हो. बोल सकते हो कि हमें सिर्फ सर्विस मार्क चाहिए, SM, वो आपके एप्लीकेशन में चला जाता है. अ वेरी गुड एग्जांपल ऑफ दिस इज सिरिल अमरचंद मंगलदास. दे हैव अ सर्विस मार्क इन क्लास 45. नीस क्लासिफिकेशन की भी बात करेंगे, डोंट वरी. एंड देयर इज सर्टिफिकेशन मार्क. सो अगर आपको किसी एक पर्टिकुलर एक अथॉरिटी के थ्रू आपके पास ये पावर है कि आप सर्टिफाइंग अथॉरिटी बन गए हो. सो फॉर एग्जांपल ISI का मार्क होता है, तो दैट इज अ सर्टिफिकेट मार्क. उसके अलग रिक्वायरमेंट्स होते हैं, वो ट्रेडमार्क एक्ट में दिया हुआ है कि आप कब सर्टिफिकेट मार्क के लिए अप्लाई कर सकते हो, एलिजिबल हो सकते हो, कौन अप्लाई कर सकता है. बट द आइडिया इज बेसिकली इफ यू आर अ सर्टिफाइंग अथॉरिटी यू कैन गेट अ सर्टिफिकेशन मार्क. Collective mark. So if you are a part of a collective, if you're a member of a group that's very well renowned, and तो आप उसका collective mark register करवा सकते हो और आप उसका collective mark as a member use कर सकते हो. For example, CS, company secretary. तो वो आपका collective mark माना जाता है. Bar Council of India collective mark. Now series mark, जैसे कि आपको अगर IPL की सीरीज को रजिस्टर करवाना है, तो आपको पता है IPL तो मेन रहेगा, उसके आगे IPL 2011 2012 आपने आगे नंबर्स ऐड कर दिया, आपने आगे सिंबल्स ऐड कर दिया कुछ, लेकिन वो बेसिक स्टेम सेम रहती है. इट बिलोंग्स टू द सेम प्रोप्राइटर, but there is a series of it that you would like to register, so nobody else can come and say कि चलो हम इसके ऊपर प्ले करके ये वाला भी अपने ऊपर रख लेते हैं. सो IPL 2011 किसी एक प्रोप्राइटर का होगा, IPL 2012 किसी और ने रजिस्टर करवा के यूज कर लिया. सो ऐसे नहीं हो, तो उसको और प्रोटेक्ट करने के लिए सीरीज में मार्क्स को रजिस्टर कर लेते हैं सेम प्रोप्राइटर्स. नाउ व्हाट इज डिवाइस एंड लेबल. सो अगर आप ट्रेडमार्क रजिस्टर करने चाहते हो तो वहां पे आपको स्पेसिफाई करना होता है कि आपका वर्ड मार्क है या आपका लेबल मार्क है या डिवाइस मार्क है. So there's not a lot of word mark, and there's only the word that will get registered. But if you want to get the logo registered, if there is a specific graphical representation or an illustration, जिसमें there are different pictures and there are different pictorial representations, then वो आपका device या label बन जाएगा. So आपको अगर अपना लोगो रजिस्टर करवाना है, to put it very simply, जिसमें there's design also, there's a particular font that you've used, there's a particular color combination, there's a particular symbol that you're trying to establish as your brand name and your brand existence in the market, then आपको वो device या label के through उस लोगो को register करवाना पड़ेगा. Now, there are some unconventional trademarks also. These were all conventional trademarks. मतलब ये तो काफी आम है, काफी regular है. There are some unconventional trademarks also. Sound trademark is known to be unconventional. In fact, इंडिया में अभी जब याहू वाला केस हुआ था, जब याहू का याहू that sound had to be registered, then that was I think the first sound mark that was registered in India. Otherwise उससे पहले क्या होता था, that until and unless there's a graphical representation of the mark that you're seeking to register, so वो पेपर पे होना चाहिए कहीं पे. अगर वो पेपर पे नहीं आप establish कर सकते हो तो आप उसको register नहीं करवा सकते under Indian trademark law. So sound को you can still put it on paper, you can still put the notes even if there are no lyrics, then उसका graphical representation हो सकता है जो आप trademark करवा सकते हो. लेकिन अगर आप smell mark पर जाओ, so for example if there is a particular kind of smell, जैसे Domino's के pizza का smell is actually a registered trademark, but that's registered in US, that's registered in European Union, but that's not registered in India. Because in India, according to the trademark law, if there is no graphical representation, then you cannot register the trademark. So it is a very unconventional kind of a trademark, but register hota hai, bas India mein nahi hota. Now, let me just look at some questions. Zeta has asked, ma'am, could you explain again the difference between the symbol R and TM? So Zeta, when you're using, if your trademark has been registered, so you have the registration certificate from the trademark registry, tab only you can use the symbol R. But if you have filed the application and the application is under review, then you can use the symbol TM next to your name. So that's the difference between the symbols. I hope that's clear. Mohit has asked, wasn't Zippo lighter the first sound mark in India? So I'm not really sure. What I recall is the Yahoo case, but that might also be because the Yahoo case was also the first cyber spotting case of our country. So I might be confused here. I can get back to you, or we can check. But the Zippo lighter, you're absolutely right. You know, the sound of the Zippo lighter opening, that is also a sound mark. We just have to figure out whether that was the first sound mark in India or not. Okay, Lasya has asked, can you please give an example of a certification mark? So ISI is a certification trademark. So we know that BIS, the Indian standards regulations. So you have to have ISI mark on certain products. So that is an example of a certification mark. Now Yashta has asked, colors can also be registered under trademark. Yes, colors can be registered under trademark. For example, the orange color of Reese's. That is a very famous example for a color to be registered as a trademark. But in India, again, the law says that there has to be a combination of colors. You cannot register one particular color. And there is, a gray area of sort in that regard, because there were some cases where a maroon color for a particular brand, or one color that's absolutely recognizable and identifiable with the services and the goods that are being provided by the brand, and that one color, if it has acquired that distinctiveness, then that color can also become a trademark. But there's a gray area on that when it comes to Indian trademark law, because here we are talking about combination of colors that can be trademark, but a single color, whether that can be or cannot be trademark, that depends from case to case. That depends on the facts and circumstances of the case that you're dealing with. So Ravi sir has also said that, I've also heard of first sound mark Yahoo. So there is that confusion that can be your, additional task for the day. Let's figure that out. Let's discuss this tomorrow. What was the first sound mark in India? So yeah, I hope that these are some basic kinds of trademarks. I hope that you have an idea about what all can be trademarked. In fact, Shah Rukh Khan has trademarked his name. He has trademarked his signature. And there are different kinds of things that you can get those, names also trademarked in. For example, Shah Rukh's trademark can be used only by him on letterheads, or when he's signing something, or basically some office products, if they have to be used and they have to use the name Shah Rukh Khan, then only Shah Rukh Khan has the rights to do that. Then Kareena Kapoor's signature has also been trademarked, and there are some very famous surnames like Tata, Birla, Mahindra. So they're all trademarks. Why? Because they've acquired that distinctiveness of distinguishing their goods and services. Even if there are no goods, there are services. There's a brand value attached to them, and that has acquired a distinctiveness from everybody else. So SRK, Shah Rukh Khan dealing in his own name, building his own brand, is something that only he can do, and anybody else using his name to dilute his brand cannot be allowed, and that's why that trademark is allowed. Now there are very weird trademarks also. For example, Usain Bolt's trademark victory dance, that is also trademarked, and only he can use that. Then there was a Salt Bay GIF that became very, very popular. So that a motion mark can also be registered, so that GIF also was registered as a trademark. In fact, recently I was just discussing this with Pragya the other day. देयर वाज दिस फेमस स्लोगन, ये गवर्नमेंट बिक चुकी है, एंड उसका लोगो बनाकर, दैट लोगो हैज आल्सो बीन रजिस्टर्ड एज अ ट्रेडमार्क, ये गवर्नमेंट बिक गई है, it was something like that, so that has been registered. Then Nokia ke there's this handshake wala motion mark that has also been registered. So anything that can be graphically represented, that can be registered as a trademark. Now it totally depends. For example, Beyonce has trademarked the names of her children also. So everything happens, anything goes, especially in the international domain of it. But in India, there are still certain limitations. There are still certain areas where India has to catch up. Now, Mohit has given an excellent example of a color trademark. Cadbury got purple color trademark in the UK. Absolutely. Dia has asked, how can trademarks, example Burger King, which contain descriptive word, be registered? Now, Dia, that's a very, very smart move on your end, since Burger King and Burger Sing is your problem statement also. So we won't be discussing that particular case in detail before tomorrow, after you guys have presented your arguments. But yeah, I will explain that further in just a bit. On the next slide, we're going to talk about descriptive and distinctive and, different kinds of trademarks, generic trademarks also. Now, Anna Mary has asked, is certification trademarks only given to certifying authorities? Yes, only certifying authorities can get certification trademarks, and their eligibility and requirements, everything, all the details have been given in the Trademark Act also. Now, this Kalian C, if you want to read about IP, she writes wonderful articles, and this is a very, very good blog that she has, Fun IP. She said that representations that do not make sense are the best trademarks. So this brings us to the next topic that we have to discuss. What are the best trademarks, And this comes handy when you are trying to advise your client. So, but there are a lot of times where your clients may even come to you and say, अच्छा ये अगर trademark नहीं हो सकता तो आप कोई और नाम suggest कर दो, आप वो काम करने मत बैठ जाना please. That's like additional thing that's not your job as an attorney, as a lawyer, to be giving them ideas. Of course, I mean, if you want to build that extra special touch wala relationship also, that you can, okay, fine, suggest if you think you're very creative. But yeah, so there are a lot of names, brand names जो आते हैं आपके पास, जो बहुत generic से भी होते हैं, so आपको पहले, before you even apply for the trademark, you should give a comprehensive legal opinion to your client whether their trademark can be registered or not, like kitni probability है registration होने की. Because we often confuse this with our general property registration वाला काम, कि आपने वहां पे जाके पेपर फाइल कर दिए, ठीक है, टाइम लग जाएगा लेकिन काम हो जाएगा, वैसा वाला जुगाड़ चल जाता है. कोर्ट्स में जाके, रेवेन्यू ऑफिसेस में जाके आप बोल सकते हो कि हाँ ठीक है, आपका ये रजिस्टर हो जाएगा, आपको मैरिज सर्टिफिकेट बनवाना है, बन जाएगा, हो जाएगा. लेकिन आप ट्रेडमार्क के साथ वो गारंटी नहीं ले सकते हो, एंड दैट इज समथिंग दैट वी आर गोइंग टू डिस्कस फर्दर टुडे. बट आपको कैसे रिकॉग्नाइज करना है, कैसे आइडेंटिफाई करना है कि जो आपके सामने ब्रांड नेम आया है, वो ब्रांड नेम रजिस्टर्ड होने के उसके कितने चांसेस हैं? सो सबसे ज्यादा चांसेस होते हैं आर्बिट्ररी मार्क्स के. ना आर्बिट्ररी मार्क्स क्या होते हैं? वो ऐसे मार्क्स होते हैं जो कोई इमेजिन ही नहीं कर सकता कि उस पर्टिकुलर गुड या उस पर्टिकुलर सर्विस के लिए वो मार्क यूज हो रहा है. फॉर एग्जाम्पल, आप एप्पल को देखिए. Apple, using Apple for technology, using Apple for mobile phones and laptops and MacBooks and things like that. You can't imagine, before this term was used by the brand owners to establish their presence in the market, you could not have imagined that Apple use होगा technology के लिए, या Apple use होगा computers के लिए. So वो एक arbitrary mark बन गया. अगर आप फैंसीफुल मार्क्स की बात कर रहे हो, फैंसीफुल मार्क्स वो होते हैं जो आपने खुद कॉइन किए होते हैं, जिनका कोई मतलब ही नहीं है डिक्शनरी में. सो फॉर एग्जांपल नोकिया, नाइकी, या आप और भी कोई रीसेस, और ऐसे बड़े बड़े कैडबरी, इनको फैंसीफुल मार्क्स बोलते हैं. व्हाई? बिकॉज दे हैव बीन कॉइन्ड, राइट? सो वहां पर उनका कोई मतलब नहीं है until and unless you relate them with the products or the services that they are providing. So उनके भी register होने के chances काफी high हो जाते हैं. So for example, there was a client that we had, Godiva. If you've heard Godiva chocolates, so वहां पर गोडीवा का ऐसा कोई मतलब नहीं है, अपार्ट फ्रॉम द फैक्ट दैट उसकी एक हिस्टोरिकल एक बैकग्राउंड है. इट वाज बेस्ड ऑन सम goddess, and वहां से you're trying to relate that with the quality of the chocolates that you're providing, and there's a history behind that name, and there's a reason why you're using that name. तो वो एक specific चीज हो जाती है for your own products, for your own services, and that is why fanciful names are also, they have a high probability of getting registered. लेकिन अगर आप generic चले जाओ, for example रोटी रोटी कपड़ा मकान, या अगर आप बोलो कि एक जेनेरिक, और आप कर लो कि यहाँ पे खाना ढाबा और थिंग्स लाइक दैट. सो वेरी वेरी जेनेरिक, जो आपको पता है कॉमन डे एवरीडे यूज में होता है, तो वो एक डिस्टिंग्विश नहीं कर पाएगा आपकी सर्विसेज और गुड्स को फ्रॉम द सर्विसेज और गुड्स ऑफ अदर पीपल आर प्रोवाइडिंग. एंड देयर आर सम नेम्स दैट आर आउट देयर फॉर द पब्लिक टू यूज हाउएवर दे वांट टू यूज. सो उस पर कोई एक राइट क्लेम नहीं कर सकता. सो वो एक जेनेरिक चीज हो जाती है. फॉर एग्जाम्पल द वर्ड पे, व्हेन इट कम्स टू फोन पे, भारत पे, गूगल पे, तो जब वो टर्म पे आ जाता है तो आप ये नहीं बोल सकते कि पे के ऊपर किसी का एक का राइट है, गूगल का राइट है, या फोन पे की कंपनी का राइट है, या भारत पे की कंपनी का राइट है. इनफैक्ट इस पे केस पे हुआ था जहाँ पे इट वाज फोन पे वर्सेस भारत पे, वेरी वेरी फेमस recent case where they discussed just that कि आपका उस पे टर्म के ऊपर कोई भी किसी का कॉपीराइट या ट्रेडमार्क नहीं है, तो वो तो कोई भी यूज कर सकता है. लेकिन आप उसको कैसे अपने ट्रेडमार्क के साथ मिला रहे हो, जैसे भारत पे हो गया या फोन पे हो गया, आप उसको कैसे डिस्टिंग्विश कर रहे हो, दैट इज ऑन यू. एंड देयर आर सम नेम्स दैट आर जेनेरिक बट दे हैव अक्वायर्ड डिस्टिंक्टिवनेस, तो उनको रजिस्टर होना अलाउड होता है. वो डिपेंड करता है कि वो कितने टाइम से ऑपरेट कर रहे हैं, मार्केट में उनकी कितनी वैल्यू है, कितना उन्होंने अपनी मार्केटिंग या एडवर्टाइजमेंट किया है, कितने लोग रिकॉग्नाइज करते हैं. सो फॉर एग्जांपल टाटा अगर आप देखा जाए तो इट्स अ जेनेरिक टर्म, अ लॉट ऑफ पीपल हैव सरनेम्स टाटा. लेकिन आप जब देखोगे मार्केट में टाटा का कोई ब्रांड का कोई सामान बिक रहा है, तो ऑटोमेटिकली यू विल रिलेट इट विद टाटा ग्रुप. So that, even though it's a generic term, it has acquired distinctiveness. So that is why it is liable to be registered. So there's a difference between well-known trademarks and that are recognized by the trademark registry, that are recognized by the trademark law, and other generic terms that have acquired distinctiveness, जैसे cars 24 और things like that. तो वहां पे आपने cars यूज कर लिया, 24 यूज कर लिया, एंड वो जेनेरिक है लेकिन फिर भी acquired distinctiveness, तो आपको registration मिलने के chances हैं. Now it depends again case to case basis, facts and circumstances, आपको ध्यान से देखना है. लेकिन अगर किसी की ब्रांड वैल्यू ऑलरेडी है ही नहीं, इट्स अ प्रपोज टू बी यूज्ड नेम, कि उसको अभी आपने यूज नहीं किया, आपने उस पर कुछ इन्वेस्ट नहीं किया, आपका ब्रांड नहीं बना है, तो आप आइडियली हम लोग बोलते हैं अपने क्लाइंट को कि आप थोड़ा सा फैंसीफुल नाम जाओ. सजेस्टिव क्या होता है? Suggestive is when you are suggesting the quality of your products or the services or the description. तो अगर आप जैसे प्रोडक्ट मार्क होता है, फॉर एग्जांपल शेप मार्क्स होते हैं, जैसे कोका कोला की वो बॉटल है, वो आपको पता है कि वो एक कोका कोला की बॉटल का ही वैसा हो सकता है. हेनिकन बॉटल्स, बियर बॉटल्स, तो उनकी जो शेप है वो एक शेप मार्क है. अगर आप प्रोडक्ट की कुछ सजेस्ट कर रहे हो क्वालिटी, तो जैसे बासमती राइस जो होते हैं, तो वो ऑल्दो इट्स इट्स अ जेनेरिक टर्म एंड एवरीथिंग, लेकिन वो अक्वायर्ड डिस्टिंक्टिवनेस है क्योंकि आपको पता है कि उसकी क्वालिटी बहुत अच्छी है क्योंकि बासमती के राइस है. तो दीज आर सम थिंग्स जहाँ पे कंफ्यूजन होने के चांसेस हैं, लेकिन इनके रजिस्टर होने के चांसेस ज्यादा होते हैं डिपेंडिंग ऑन कि उनकी कितनी एग्जिस्टेंस रह चुकी है मार्केट में. Now there are some questions that I'll be taking right now. So Dia has asked a question. Sometimes we do public search in one class and the name is clear in particular class, but later opposition comes from other class. Yes, absolutely. We're going to discuss that today. That's a very, very, good question or a good observation right now. I'll just discuss that in detail. Zeta has asked, ma'am, so what is the difference between arbitrary and fanciful marks? So, for example, arbitrary is basically there is an existing name already, but you won't associate that name with the goods or services that are being provided. For example, apple is there, apple is a fruit, but आप उसको associate नहीं करोगे कि वो एक लैपटॉप बेच रहे हैं या वो एक मोबाइल टाइप बेच रहे हैं, तो वो एक arbitrary term बन गया. Fanciful is something that you have coined yourself. For example, अगर आप देखो कि प्रज्ञा ने अपना शो बनाया, प्रज्ञा अरोड़ा, right? So the Pragya Arora show. So that is something that is not directly suggesting exactly what is she doing. At the same time, there's not any other Pragya Arora show. So she has coined that sort of herself to relate that with her own brand value. So that becomes fanciful. So fanciful is basically when you are creating words that don't actually have a textbook definition. So आपने वो बना लिया, जैसे Cadbury is a fanciful mark. So she's asked, surname Agarwal can be generic or has it become distinctive over the years? So Agarwal is generic. To make it really, really distinctive, it has to be at the same level as Mahindra, Tata, or Birla, So that is actually also what I wanted to discuss with you. There's a list of well-known trademarks. And Pragya will show where the list can be found on IP India website also later. But there is a list, and only if your name or your mark is on that list will you be recognized as a well-known trademark. You can't just say that any trademark that you are aware of or that you know about, that trademark can be well-known because you've heard a lot about this. No, it has to be. So earlier, what was the norm was that the High Court would decide whether a trademark would be a well-known trademark or not. But now, after 2017 and 2019 amendments, what has happened is that a proprietor can apply to the registry to register his or her mark as a well-known trademark. And then the registrar will decide whether or not it is a well-known trademark. And if it does get registered as a well-known trademark, then it comes on the list. So there's a list of well-known trademarks, and only the names that are on the list are known to be well-known trademarks. Now, what is the difference? How is it better if you have a well-known trademark is something that we'll discuss in the following slides also. But just remember this, like 7-Eleven, Bajaj, etc. They are all well-known trademarks. And if they, their mark is getting diluted, even if it is by a brand name that is selling some completely different services or different goods, even then the well-known trademark will have a higher probability of securing their mark, securing their brand value, and they'll have a higher protection, a better protection from the registry, from the courts. So Karishma has asked, could you explain sound marks again? So sound marks are basically just when you can identify a particular sound from the goods and with the goods and services of a particular brand. So like, the opening of a Zippo lighter, or the Yahoo sound of Yahoo, or, there are the Nokia ringtone, that is also a sound mark. So those are the sound marks, and the graphical representation can be registered. So we know that, the sound marks, the musical notes can be graphically represented, so they can be registered. Netflix sound too. Yes, Netflix sound now can also be, it is also a sound mark. Airtel jingle is also a very good example. Thank you so much, Ravi sir. Thank you, Natasha. Now, just to recap, when you see the word M, the golden arches, that is the logo. When you see I'm loving it, that is a slogan. And when you, see this in entirety, this is a label or a device. So with the M arches, I'm loving it, the particular color scheme, the particular font, the particular size, all of this will come together to form a label or a device mark. If you have to get the individual parts registered, you can get the I'm loving it slogan registered. You can get just the golden arches, just the logo registered. You can get McDonald's as a word mark registered. So, there are different kinds of registration applications that have to be filed. So it's not that आपने एक एप्लीकेशन में बोल दिया कि सब कुछ रजिस्टर कर दो, आप हमारा वर्ड भी कर दो, आप हमारा लेबल भी कर दो, लोगो भी